Dear friends, and now for something completely different, as, who was that? Monty Python's Flying Circus used to say. After having explained about the illegally issued and totally false arrest warrant, I will now speak about the most complicated part of my criminal complaint, that section in my criminal complaint which outlines how Judge Schindler, in his fake case against me, committed the very serious felony of perversion of justice. He did this with the legal directive he issued on May the 3rd, 2024, when he instructed us that from then on, this case would no longer be about illegal loans, that is, loans that were taken out in violation of corporate law. Rather, he informed us that from that day on, May the 3rd of 2024, he would try to convict me on the charges of violation of a secret trust agreement, whatever that is. We were all of us dumbfounded when we heard this, and it made absolutely no sense, as it had no basis in anything. And on top of this, it showed that Schindler didn't even understand the most basic principles of civil contract law, Contracts 101, or, for that matter, the most basic principles of criminal law, the foundation of criminal law, and that's a fair trial and not a trial by ambush. In fact, at that point, I'm serious. I seriously began to wonder if this man, Judge Schindler, had actually graduated from a real accredited law school, or maybe he had just purchased a law school degree from whoever. But then, being dumbfounded, this state of being dumbfounded by this remarkably idiotic first part of his legal directive gave way to a sense of real shock when he also announced in the second part of his ruling that he would effectively shut the hearings down and would not even hear any of the other witnesses proffered by the prosecution with their list of witnesses, and that he certainly would not hear any of the witnesses that the defense wanted to put on the witness stand in order to rebut these obviously freely invented and, we thought, insane new charges. This breathtaking assault on the very foundations of a criminal trial, the right to a fair trial and to a fair hearing, immediately prompted the defense to move for a stay, that is, a pause of that proceeding, so that we would be able to adequately prepare a defense for this completely new situation. But of course, he wouldn't let us do that. He gave us no time at all, but rather asked us to now start with our closing argument. That's a completely unheard of double whammy, in that we were now confronted with not only a trial by ambush, but with a patently idiotic trial by ambush. This denial of a fair trial and a fair hearing is in direct violation of the German Code of Criminal Procedure, which demands that if a judge issues a legal directive to the parties, alerting them to something that they were not aware of before that legal directive, in this case new facts, he, the judge, must stay the proceeding in order to give the parties enough time to adjust to the new situation and adequately prepare a new defense. We do believe that this is common sense, and that in order to understand this, one does not have to study law. Surely, the reason why a judge notifies the party of a criminal trial of a new situation can only be to put them on notice and give them a chance to prepare for that new situation. Two questions arise from this. Why did Schindler do this? And where or from whom did he get the idea for these ridiculous new charges? Question number one is easily answered. As is spelled out in the fake arrest warrant and also in the equally fake and completely false indictment, the prosecution deemed the loans that my former co-host Vivian Fisher and I had taken out to be illegal because, in their mind, they violated corporate law. That is, were in violation of corporate law. As I also explained, any prosecutor with a pulse and at least one functioning eye would have, had he investigated these allegations at all, at once understood that they were dead wrong and that the loans, at least mine, were perfectly in line with corporate law. And that's because the only thing that counts when it comes to loans that a shareholder of a corporation takes from that corporation, the only thing that counts, in my case it was I as a member of the Corona Committee taking the loan from the Corona Committee's donations. But the only thing that counts in such a situation is that the taker of the loan at the time of entering into that loan agreement is both willing and able to pay back the loan. That's all. Since we both took these loans in order to protect part of the donations from imminent seizure of the donation money by the deep state's puppet authorities, so that if they did seize that money, we would still be able to pay for and continue with our work, we were, of course, both willing to pay back that loan. My motivation to pay back that loan was even stronger, as I had on numerous occasions stated publicly that I needed the facts, the findings that we had gathered with the help of this investigation of the pandemic as evidence. I needed it as evidence for many lawsuits to be started all over the world, both criminal and civil, to hold the individuals, the corporations, and other entities to account who were behind the pandemic and behind the measures, such as the lockdowns and the aptly named shots. And, of course, I was not only willing to pay back the loan, but I was also able to pay back the loan, as I, unlike Vivian Fisher, who as it turned out had no income and next to no assets, I had more than enough money and assets to pay back the loan at any time. When this had become clear by late April of 2024, Judge Schindler was forced to throw the case out and set me free, at least under the law. He was forced to do that. And he was not necessarily to do this, but he should have eaten the arrest warrant, which so desperately he had wanted to uphold, and which he had no problem in suppressing the evidence that showed that it was completely false. But that, of course, he couldn't do. Why? Because his handlers had ordered him to, as quickly as possible, put behind bars as long as possible, at least for 4 years. That in itself, of course, has nothing to do with justice at all. And the absurdity of these orders to put me behind bars for as many years as possible, this patent absurdity becomes clear if you take into consideration that and I'm not trying to blow my own horn here, I'm simply stating the facts, that I, up until that moment, was an internationally successful lawyer with no criminal record at all. And it becomes an outrageous insanity if you then take into consideration that the Göttingen criminal justice system is now infamous for not only covering up murder cases as tragic accidents and suicides, remember that story about the 16-year-old girl who was killed, but also they have become infamous for letting the murderer go even if he leads them directly to the site of the killing and the dead body, at least so long as that murderer is an asylum seeker whose request for asylum was denied and is not an attorney like me. So there Schindler was in late 2024, taken by surprise by the unexpected turn of events in this fake trial against me, which apparently he had stumbled into totally unprepared as someone who neither understands civil nor criminal law. In fact, taken by surprise by the testimony of the prosecution's most important witnesses, as a result of which it suddenly became impossible for him to convict me of anything. On the contrary, he found himself in a situation in which he was forced to admit in writing that the authors of the criminal complaint had stolen my money and that I would have, of course, used that money to pay back the loan had it not been stolen by them. Had he been a real judge, he would indeed have thrown the prosecution's case out and let me go. And he would have made sure, as this was his legal obligation as a judge, that a criminal proceeding was started for blackmail and fraud against the authors of the criminal complaint who had stolen my money. That, however, would have been a violation of the orders he had gotten from his handlers. Remember, this is something that my defense attorney, Dr. Christophe Miseret, told us in court and confronted the court with when he asked them if they could comment on the information he had gotten from a whistleblower from Germany's intelligence service. Well, that's the reason why Judge Schindler acted how he did and how he is now guilty of having committed the very, very serious felony of perversion of justice. Not just an attempt to pervert justice, but he is guilty of this felony. Okay, before I talk about where or from whom Schindler got the cue or the idea for the new charges announced on May the 3rd, 2024, let me put all of this into context. Remember that I was not charged with a serious crime, with a felony. I wasn't charged with theft, fraud, or embezzlement. Rather, I was charged with a very mysterious crime of having violated a fiduciary duty to take care of someone else's money by taking out a loan from the Corona Committee. By having violated a fiduciary duty to take care of someone else's money. Oddly enough, Schindler was of the opinion that this money, the donations, were not the donors' funds, donors who had donated the money because of our promise that it would be used for one purpose only, namely the investigation of the pandemic, and not for ourselves. Rather, Schindler proclaimed that this was, in his opinion, money that belonged to the two substitute members of the Corona Committee, the two persons who had never been interested in furthering this goal or purpose of the Corona Investigative Committee, who, even according to Vivian Fisher's testimony in court, had never contributed anything to the Corona Committee at all, but whom even she suspected of sabotaging the Corona Committee's work, and who had, from the outset, it now seems to be clear, had only been interested in taking the donations and using them for themselves. So what is it with this mysterious crime of violation or violating a fiduciary duty of care for someone else's money? What makes it so mysterious? First off, you'll remember that this crime was invented by the Nazis in the Third Reich, and it was intended as Judge Freisler, the Nazis' highest judge and president of the so-called People's Court, the monster who first tortured members of the resistance against Hitler and then had them executed. He writes that the intent of this mysterious law is to serve as a catch-all crime to go after any political opponent. Interesting, isn't this? Secondly, many German legal scholars to this date are of the opinion that this crime, the violation of a fiduciary duty to take care of someone else's money, is so vague and overbroad that it is unconstitutional on its face. Thirdly, you will also remember that Prosecutor John expressly referred us, the defense, to a legal article that he had read when he tried to understand what he was doing. And in this article, a professor of law, citing several other acclaimed professors of law, warns of the clear and present danger of this crime being used, or rather misused, to get an either stupid prosecutor or a prosecutor who simply follows orders to start a criminal investigation in a non-criminal setting. Why would he do that? Well, to put pressure on the accused to make him agree to pay money to the person who filed the criminal complaint so that that person, the accused, would agree to pay money that under normal circumstances the author of the criminal complaint would have no chance whatsoever of getting in a civil proceeding. Sounds complicated? Well, what does this mean for this case? Well, here we have the three signatories of the criminal complaint who want to get the donation money from the Corona Committee or from the corporation who they claim is behind the Corona Committee and who they claim whose shareholders, two of them, are. This is clearly a civil case involving, obviously, corporate law. And the Three Stooges from Berlin, miraculously enough, seem to understand this, as they informed Prosecutor John already on January 18th of 2023 of their intention to file a civil complaint against me. Had they done this, then of course they would not have been able to continue with the criminal case against me, because evidently this is not a criminal case, but it's a civil case involving corporate law. That's civil law. And civil law, in such situations, takes priority over criminal law. That is why someone, we don't know who yet, told the Three Stooges not to file a civil complaint quite yet against me, but keep pursuing the fake criminal case. The other reason they didn't do this is that they stand no chance of winning a civil case against me. First of all, they have no standing, as the corporation which they claim to be shareholders of does not exist and never did exist, as a Berlin prosecutor correctly stated. It's all in the file. And the reason is that the two substitute members of the Corona Committee, who because of their loser status so desperately wanted to get their hands on the donations, proclaiming that they're shareholders of the non-existent Corona Committee Corporation, refused to get that corporation registered. In short, both in law and in equity, they stand no chance of winning a civil case against me, as they acted in bad faith when they refused to get the corporation registered only because they wanted the corporation to fail so that they would then be able to get the donations. I'll spare you the details of this civil case, which in the meantime they have filed. Actually, they filed it a couple of days or a couple of weeks before Judge Schindler was going to announce his sentence against me on April 24th, 2025. And they also asked the civil court to stay the civil case until Schindler's criminal ruling would be final. Suffice it to say that that civil case will be crucial for the survival of the Göttingen judiciary, as Göttingen's criminal judiciary is now dead in the water and far beyond the point at which it could have still been salvaged. So now back to question number 2. Who or what gave Judge Schindler the idea for the new charges, the new facts he invented on May the 3rd? Let us first take a look at what exactly he invented on May the 3rd when he decided to suddenly drop the charges of illegal loans and from then on to pursue the idea of this secret trust agreement. Here's what he writes in that legal directive. Number 1, yes, Dr. Fuellmich and Vivian Fischer had concluded loan agreements for the purpose of protecting part of the donation money from getting seized by the authorities. And number 2, before or after or at the time of the conclusion of the loans, this remains completely unclear, we, he claims, had also in another so-called sham agreement, agreed that these loan agreements should be null and void. And third, this was done, he further fantasized, to conceal the fact that in reality a trust agreement, or several trust agreements, this remains completely unclear, that a trust agreement or several trust agreements had been concluded between me and Vivian Fischer. When this happened and what exactly this secret trust agreement or these secret trust agreements state remains, you guessed it, completely unclear. And number 4, he says, based on this secret trust agreement or a multitude of secret trust agreements, I, or both I and Vivian Fisher, again, that's unclear, were to transfer the money from the Corona Committee's bank account to our own private bank accounts and keep it there as what he calls a liquidity reserve. That's a complicated agreement, right? It's a complicated and secret agreement. And he continued, since I, unbeknownst to Vivian Fisher, had used the money for private purposes, as I had invested most of it in the last of the 5 houses I had owned in Germany, and I had sold 4 of them, so as to enhance the value of this house, he concluded this was a violation of a fiduciary duty to take care of not the donor's money, but of the 2 substitute members of the Corona Committee's money. Never mind that none of this had happened unbeknownst to Vivian Fisher, who herself had spent her loan for herself, as she had neither any income nor any asset. Never mind that Schindler in his legal directive writes that Vivian Fisher did indeed know that I, as we had both agreed, would make that money disappear by parking it in my last remaining property in Germany so as to be able to sell it at a higher price. And never mind that Vivian Fisher, when asked by Judge Schindler in court if she had ever spoken to me about a liquidity reserve, answered no. And never mind why Vivian Fisher and I, both being attorneys, would not simply enter into a trust agreement if we had wanted to conclude one. Schindler did, because there was no other way, concede that this highly complicated agreement he had invented, loan agreement, sham agreement, to conceal a trust agreement with a liquidity reserve, he agreed that this highly complicated fantasy of his did not exist in writing, nor, he says, was it agreed upon orally. That's strange, right? It's Contracts 101. Rather, he said, he concluded that such an agreement or such agreements, such deals had been struck between me and Vivian Fisher. He concluded this from several chat messages Vivian Fisher and I had exchanged more than a year and a half after the loan contracts had been entered into, and from 2 emails we had exchanged before the loan contracts were entered into. Now, nothing, absolutely nothing in those chat messages points to Schindler's fantasies, Schindler's list of fantasies. There's not one word about a sham agreement or secret trust agreement or liquidity reserves, nothing. We only talk about loan agreements there. And the 2 emails he refers to were written before we entered into the loan agreement, and they neither contain any reference to any of Judge Schindler's fantasies, or what these 2 emails do reflect, however, is that Vivian Fisher and I had discussed that she would have her loan transferred to a bank account she held in Liechtenstein, and that I would have part of my loan transferred to my client's trust account in California. But then Vivian changed her mind and didn't want to pursue that idea any longer. She wanted to keep the money in Germany. So we abandoned it and simply went for the loan agreements. That's all. So now back to the question of how did Schindler get the idea for that highly complicated construct he announced on May the 3rd, 2024 in his legal directive. This is indeed another crazy story in and of itself. Remember how I told you in my statement about the fake arrest warrant that we had destroyed the arrest warrant, by telling the judge before whom I stood on November the 1st, 2023, to finally give my own account of what had happened. Remember that we had told him, explained to him, showed him that every single accusation in that arrest warrant was false, and that the loans were perfectly legal and in accordance with corporate law. Remember also that both Katja Verma, my attorney, and I were surprised to see Prosecutor John literally flee the courtroom right afterwards, that is, right after his arrest warrant had collapsed like a house of cards, only to make a phone call in which he asked a former senior prosecutor who had in the meantime become Vivian Fisher's attorney for help. That former senior prosecutor had responded to this SOS call with a letter dated November 12th, which starts with the sentence, Dear Prosecutor John, with reference to the telephone conversation held on November 1st, 2023. And in that letter, he then writes, it should be noted that when signing the loan contracts, Mrs. Fisher was certain that Mr. Fuellmich would keep the loan liquid in accordance with the agreement. He doesn't say in accordance with what agreements, and there's nothing in the loan contracts to this effect, and that he was willing, she was convinced, or she believed, that he was willing and able to pay it back when necessary. Again, there is nothing in the simple private loan contracts we both signed that said anything about me or us having to transfer the money into private bank accounts and keep it there as a liquidity reserve. But this is how this former senior prosecutor had responded to junior prosecutor John's call for help when on November the 1st, John's arrest warrant and his case had collapsed in front of Judge Mook. And a few days later, with another letter dated December 5th, 2023, this senior prosecutor sent John the chat and email messages which Schindler later relied on in his legal directive of May the 3rd, 24. This, of course, begs the question, what role does this former senior prosecutor and attorney of Vivian Fisher play in that proceeding against me? Was he, too, one of the puppets of the deep state? But if so, why did he attach an affidavit to this letter in which I declare in a civil dispute between Vivian Fisher and myself under penalty of perjury that we had only concluded loan contracts, nothing else, no trust agreements or anything? And why did Prosecutor John, who was thus being alerted to the fact that there was not just a simple statement by me, but an affidavit which directly contradicts Vivian Fisher's allegations, why did he not investigate, as he should have, to find out who was telling the truth? She, Vivian Fisher, or I? Questions over questions. But if you give this senior prosecutor the benefit of the doubt, he was trying to cover his behind because he didn't trust his own client. And he did it even at the expense of helping me. Why is that? Well, if you nod off now, you're excused. But if you're interested, here's the rest of the story. Here's what we found out in the file. Vivian Fisher first attempted to tell the prosecution that she did not commit any crime by taking a loan, when she herself was also being investigated by Prosecutor John in early 2023 for violating a fiduciary duty of care to take care of other people's money. After all, she had done the very same thing that I had done, namely taken a loan to protect some of our donations from getting seized or attached by the authorities. And in order to show that she hadn't done anything wrong, she had her attorney, this former senior prosecutor, write to Prosecutor John on March 21st, 2023, that yes, she had, just like me, taken a loan. And she said that that had been perfectly okay, as we had done this to protect some of the donated money from getting seized by the authorities, who were willfully and arbitrarily going after anyone who had become critical of the government's corona measures. And he said on her behalf in his letter that this was not a problem because we both had always been willing and able to pay back the loan. So far, so good. And then he also writes that we both had, that's strange, that we both had agreed to transfer that money from the Corona Committee's bank account to our own private bank accounts and keep it there as a liquidity reserve. Doesn't make any sense, but I'll get to that in a moment. That was, in fact, a blatant lie. And as that former senior prosecutor quickly realized when he found out, Vivian Fisher had, of course, not kept any money in her own account. Rather, she had spent it all, as she neither had any income nor did she have any assets. In fact, her financial situation was so precarious, as she wrote in many of her private chat messages, that she did not know how to make ends meet, and even asked our bookkeeper to transfer almost, I didn't even know about this, to transfer almost 60,000 euros in donations to her so that she would be able to pay for her living expenses, including her health insurance. When that senior prosecutor found out that she was lying, he immediately stepped back from this letter of March 21st, rescinded everything, and said in a new letter dated April 12th that unfortunately his client did not keep that money in her account as a liquidity reserve, but that didn't matter. Why? Because her rich husband, he said, had enough money to bail her out if necessary. The defense had no way of checking out whether or not this was true, as the prosecution is withholding the documentary evidence that was allegedly attached to that letter to show that indeed Vivian Fisher's husband was a wealthy man. But a video of a fight between Vivian and her husband, which she herself had filmed and made public, and which we showed the court, suggested otherwise, as both fighting parties in that video, she and her husband, stated in a shouting match that her husband had neither any income nor did he have a job. In fact, if he had been as wealthy as Vivian Fisher claimed in that first letter of March 21st or second letter of April the 12th, 23, he would, of course, have helped her pay back the loan, which clearly he did not. And that's how Vivian Fisher, but that's a totally new story. I'm just alluding to this. I'm not going to explain anything. She was forced to embezzle money from people who, as part of a pre-sale arrangement, had paid her money for a book that was to be printed and delivered in August of 2022. Now, instead of doing that, she took that money, embezzled it, and used it to pay back her loan. And that's how she wasn't able to print and deliver the books that she had promised on the basis of this pre-sale agreement. And to this day, there are dozens and dozens, possibly hundreds of people who have paid Vivian Fisher for a book that they never received. We have a list of these people. At any rate, be it as it may, once again, without investigating anything, Prosecutor John ended his criminal investigation of Vivian Fisher and let her off the hook by simply writing on April the 19th that everything was fine, as Vivian Fisher's husband had always been willing to help her out and pay back the loan. What does this mean? Well, clearly it means that the loans were okay, according to the prosecution, so long as someone or anyone was willing and able to pay it back. Very strange. So when we, that is the defense and I, read about this somewhat strange and almost comical interlude in the file, we concluded, of course, that the bizarre notion of protecting part of our donations from getting seized by the rogue German authorities by simply transferring the money from the Corona Committee's bank account to our private bank accounts and keeping it there as a liquidity reserve, that this bizarre notion did not play any role anymore. Why was it bizarre? Well, if you want to protect money from getting seized in a bank account and then you transfer it to another bank account and keep it there, that leaves a paper trail so that the authorities who want to seize that money know exactly where to strike next. But after all, what other conclusion can you draw from the prosecution's dropping all charges against Vivian Fisher and stating that it didn't matter if the money from the loans was not kept as a liquidity reserve in a private bank account, as long as anyone else would step in and help out with the money if it ever became necessary. Accordingly, when we read about these weird scenes inside the gold mine of someone's warped brain, we decided that we're now back to square one. We're back to, and the prosecution, of course, was back to square one, which is back to the question of whether or not the loans we had taken out were in line with civil corporate law or not. Again, that means that after that little detour, we would simply have to focus on the settled law, which says that it is okay to take a private loan from a corporation so long as the taker of the loan is both willing and able to pay back the loan at the time of entering into the loan agreement. And that, as even Judge Schindler had to concede shortly before he changed course with this legal directive on May 3rd, was no problem at all, as I had always not only been willing to pay back the loan, but unlike Vivian Fisher, I had always been able to pay back the loan. I don't blame you if your head is spinning now, but this is the true story of how Judge Schindler, or a man who says his name is Schindler and who also says that he's a judge, decided on May the 3rd, 2024, that he was free to invent new charges out of thin air in order to put me behind bars for effectively more than 4 years by simultaneously and abruptly announcing that his brand new fairy tale was absolutely true and no one must question it. And therefore, he says, there was no need to give the defense an opportunity to rebut this fairy tale. It does seem a bit odd that this bears a remarkable resemblance with how that other fairy tale, that of the pandemic, was told, doesn't it? So in concluding this segment, this most complicated segment of my criminal complaint, I cannot think of any songs. I can only think of some of the stuff Weird Al Yankovic did. And I would love to hear William Shatner as Denny Crane in Boston Legal say Danny Crane. See you all soon.